Hi everybody, Professor Hutchins here. Wanted to offer you a few study tips for business law. Um, Business law is, for some students, a challenging class. Some students like it and still find it quite challenging, and some students just, it's not their thing. And I understand that. I think a lot of people who are attracted to study of business, they are not people of the book, we might say. They're people of the spreadsheet, people of the PowerPoint deck, and they're good communicators, but if they had really wanted to read dense text uh, with a sort of obsessive attention to detail and then talk about abstract ideas, maybe for them that would have been an English major, right, or a history major. So it's unfamiliar because you haven't studied it before. It may not be your natural thing, but I think everybody can do very well studying business law, but they have to hustle a little bit. And then let me give you some specific suggestions. Number one, you got to read. I think every professor says that. I mean it. Right? I don't know how to do this. I don't think you can do well in business law without reading. You've got to read. And in our culture, sometimes attentive reading, sustained attention to a text is not something that we get a lot of practice at, right? We read tweets, we watch television, um, we listen to music. We do a lot of things that we consume information through, but sort of spending time with focused attention is not the norm. So that's the first challenge, is you got to get yourself to read the material. Then I think what you want to do is when you read this material with care, you want to keep a vocabulary list, right? There's so many new words in law, whether, we're talking about a writ of certiorari or quasi-contract or a doctrine of respondeat superior or a promissory estoppel, right, or the parole evidence rule. There's just so much vocabulary, and you got to keep up with it. So make flashcards, keep a list, do Quizlet, do whatever it takes, but pay attention to the vocabulary. And so when you see a word in bold in the text, it's highlighted in that way. That's a red blinking light saying, "Pay attention to me." You want to do that. What else besides making vocabulary list and reading carefully? I think an outline is important. I think that the syllabus gives you an outline. It tells you the topics that we're studying. You should be explicitly paying attention to, okay, what am I studying? All right, I'm learning about contracts. Here's a day we're talking about the statute of frauds. Here's a day we're talking about the meaning of assent, right? Just pay attention to the outline in the syllabus. Then look at the outline in the textbook. There is a table of contents available on the website for the textbook. And then within each chapter, there's subheadings. I think you actually want to copy that out, right? This is a chapter about the statute of frauds, and it's got subheads that are going to basically tell you things about it, right? Like, that when you are falling within the statute of frauds, you have to have a writing. So you need to know when that's triggered, because the normal rule is oral contracts are enforceable. So you need to know that it's about, contracts for an interest in land or in consideration of marriage or to be an executor or to answer for the debts of another, or things that can't be performed within a year, or things that are over $500 for the sale of goods for the UCC, right? Those are subheads typically in the chapter. And so if you're writing it out as an outline, you're going to get the benefit of not just sort of passively reading it, but having a more intentional, mindful, active stance to the material. That's going to help you a lot. Then I think for the cases, as I've said, you've got to brief them. The day that everybody did that for class and turned them in, the quiz grades were superb. On days where people have sort of kind of meant to do it but didn't quite get around to it, quiz grades are not typically as good. So I think you should brief every case. And you've got a different video and a different reading that tell you how to do that, right? Then, besides all of that detail, I think you got to boil it down to one principle that the case stands for, a sort of rule of law. It's there to teach you something. So what is the law that it's teaching you? And when you write the brief, you got to be super attentive to those facts. That's very intentional. We want to practice close reading. That's a good skill for you in life. It'll be helpful to you, not just in college, but throughout life. So unapologetically, I do want you to learn all those details and the procedural history and all that stuff. But when we get to the exam, am I going to ask you what the middle court said before it was reversed? I'm not. I'm not even going to ask you the name of the case except to remind you of it, right? And I'm not going to ask you anything that's really specific to that case. I'm here to be sure you learn the principle of law, right? So we read that great Hamer v. Sidway case, right, about the Uncle Story, who told his nephew, Story Jr. or Story the Second, that he would give him $5,000 if he didn't drink, smoke, gamble, or curse. And the nephew said he did that till he was 21. So the uncle said, okay, I'm going to give you the money, but I'm going to keep it till you're old enough to handle it. And then the uncle died, and the executor didn't want to give him the money, give the money to the person that had acquired the claim on it. And so, so there was a lawsuit. Right? A really fun case about all that kind of like $5,000, or in today's dollars, maybe more than $80,000 for just saying no. And would any of us take that deal? It's all fun to think about, but what's the legal rule that it all stood for? Forbearance is consideration. That's all it is, right? Forbearance, giving up a right to do something you have a legal right to do, is legally valid consideration. Now, some people, as we saw in class, would pay $50 million for a Jeff Koons sculpture that looks like a poodle made out of balloons. It's actually metal, but you know, and other people would find that to be unconscionable, shocking that somebody would pay $56 million for that kind of a statue. The courts don't care if you paid a peppercorn, a mustard seed, $1, or $56 million. It's all valid consideration, and so is a forbearance. So a forbearance can be legally good consideration to support a contract. That's what you need to know. So make a vocabulary list, write an outline, boil the cases down after you've briefed them and learned the details. Boil them down to a sentence that doesn't involve the names of the parties, right? That's just a general principle of law. Like Cain killed Abel. That's a story in the Bible. Thou shalt not kill is a general principle from, you know, the Ten Commandments, right? So we'll talk about all the details of Cain killed Abel and what started it and who, you know, swung first and what the first tribunal said and then what the Sanhedrin said, or, you know, we could go through all the procedural history and all the messy facts, but at the end of the day, thou shalt not kill would be the law, right? If we were in the Old Testament, if that analogy is helpful to you, right? Mrs. Volks got sold a lot of dance lessons. There's a lot of complicated, interesting, you know, facts about it. At the end of the day, fraud can be a way to avoid a contract. And even in some cases, a statement of opinion, not of fact, can be a basis for a fraud claim to avoid a contract. Right? So you boil it down to the essence. Now, after you've done all that, what else do you need to do? You need to push your notes away. You need to push your notes away and you need to talk about it. You need to say, I've been studying contracts for weeks. Here's what I've learned. I know what a contract is. Right? I can explain that. I can tell you how to get into one, what elements you need to have. I know you need an offer. I can tell you about what's a legally offer. I can tell you something about the objective theory of contracts because I read that case about the farmer who ended up having or the farm that ended up being sold in Lucy v. Zamer, right? That it didn't matter what somebody subjectively thought. It mattered what the person in the position of the offeree would reasonably think. So we use an objective theory of contracts, and I learned that. So I know what a good offer is. And I know what a good acceptance is. I know that it typically has to be the mirror image of the offer or it's a counter offer that destroys the offer, right? So I know what a good offer is, I know what a good acceptance is, and I know something about consideration. We just talked about how forbearance can be a consideration. So you know what a contract is, you know how to get into one, and then you know some ways to get out of one, right? Or to be in what appears to be one that isn't. If it was illegal, if it was about gambling or, you know, selling a kidney, or taking out a hit on someone, those are not valid activities under the law, so the contracts based on them are not. We even read a case where somebody said making a legal product, a bong or a roach clip, because it would be used in consuming marijuana in the 80s when that was illegal everywhere, that was a contract that a court chose not to enforce, right? That might be different today, certainly in some states. But we know that illegality can prevent a contract from being enforceable, as can the capacity of the parties. If one of them was a minor, was intoxicated, was insane, was, you know, the victim of duress. We know if a contract is unconscionable, if it's against public policy. We know that if there's fraud involved, we know that if you have to have a writing and you don't, that can be a way to avoid a contract, right? And now you know not only how to get into a contract, some ways to get out of one, you also know some things about the way they're interpreted, right? You learned about the parole evidence rule. You know what a merger and integration clause is. And then we're going to learn in our next session before the exam something about damages and how contract damages work. And they're not like tort damages. They're not supposed to be typically punitive. They're just supposed to put the person in the position they would have been had there been the deal, if they had gotten the benefit of the bargain. So it just tries to restore them to something of what they would have had if things had gone as had been planned. Okay, so I hope that's helpful, giving you some thoughts about how to prepare for your next exam. You can all do it. I know you can, but it's not my job to just say, everybody gets a trophy and a hug. I like you. I want you to do well. I know you're capable, but in order to do well, you have to exert yourself. You have to apply this, and you have to really learn some business law. You can, so go do it, and you'll do well on the exam. Good luck.